thank you all for joining this this course on Zoom on theory, methods, and identity of European legal scholarship, confronting Carl Schmitt. The lecture here, or this talk here, it will be a lecture because I think it's very difficult to engage in a seminar-like way on Zoom. So I will mostly lecture you. But if you have any point to come in, please do so. Just speak up, unmute yourself and speak up, and then we can come into a discussion. Now, it's a big title. It's Theory, Methods, and Identity of European Legal Scholarship, confronting Carl Schmitt. So that title could be understood as holding an impossible promise. And of course, I cannot elaborate all these issues, but we can have some inroads into the topics that I hope will be interesting for you. And what I can promise you is that at the end, I have a very liberating insight for you, a very liberating insight. But that will come at the end, so you have to bear with me for another hour and 40 minutes, although we will take a 5 minutes break at about at about 11. Oh, yeah. Okay, so I have a new technique. You see me in the picture, but that new technique gives me some technical problems. So okay. So what is the purpose of this class? So we have 5 big topics, as I said. So one is on legal theory, and that is particularly demanding because I'm speaking at the Max Planck Institute for Legal History and Legal Theory, and I can also tell you that the liberating insight that I will give you at the end, it will be very polemic in this institute. It's a polemical thing. So that is one reason why I think it might be interesting. It's also on legal method. Now, legal method and legal theory, it's not the same thing. Don't forget that the juristische Methode, the juridical method, it's a method of doctrine. It's not a method of theory. Then the third critical topic that we will be discussing is identity. And that indeed is a very, very slippery and dangerous concept. One of the most dangerous concepts that we are having in Europe. Don't forget that the far right in Europe identifies under the concept of identity. The far right group in the European Parliament, it's the group of identity and democracy. And we have identitarian movements all over Europe, and these movements are very dangerous. They are very often connected with Schmitt. So we have a third concept, which is critical. And then at the end, we are speaking of Carl Schmitt. And Carl Schmitt is the Mephistopheles of legal scholarship. Now, how can we all that get together? So I'm a lawyer. I'm a German lawyer, and that's why I start with a legal text. And that text, so I have to move on, is Article 2 on European Union. And since not all of you are European Union lawyers, so I will read it out to you. And that is the most basic legal norm that exists in Europe at the moment. It's our basic norm, but so I read it out to you. It's our point of departure. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. So that is a very important norm, and you have it very important. It's all over the news this week for 2 reasons. One is the decision by the Polish Constitutional Court on Wednesday that the Polish constitution trumps European Union law when it comes to the independence of the judiciary, and the Union is fighting back on the basis of Article 2, on the basis of the rule of law. And at the same time, we have the controversy with Hungary with respect to LGBTQ people. And here again, the very point of contention, the very point of critique, the very point of reaction of the European Union in that respect is the respect for human dignity and for human rights. For that reason, Article 2 is the core norm of European. So why do I start with this Article 2? There's one concept in Article 2 which is the cornerstone of my lecture today, and that is the word society. Yeah, these values are common to member states in a society in which pluralism, etc., prevail. So what does the treaty, and that means to say the 27 political systems of the member states, together with the institutions of the European Union, what do they tell us? They tell us that 70 years of European integration have brought about not a federal European state, nor a European people, but what it does have achieved is a European society. And that society, in that society, law has a crucial role. And that you find in the word prevail. You know, these values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Now, the English word prevail is a somehow open concept, but the thing gets much clearer if you look at the French version or the German version. So in the French version, it says that the society is characterized by these principles and values. And German version goes even further. It says ausgezeichnet. Die Gesellschaft ist ausgezeichnet by these principles. So what does Article 2 and thereby all the political systems together tell us? It tells us that law has a foundational role for European society because it characterized by these values. So there's a foundational role of the law for European society. Okay, now we move on. And what I will do now is I want to convey to you an insight that I hope it will bolster your self-esteem as a legal scholar. That brings me to the next slide. Okay, that's the next slide. So who are the four people on those slides? So the one on the left, it's easy, it's written, it's John Maynard Keynes. But who are the others? So that's a question to the audience. Who can come in, please, and identify the people on the slide? Any suggestion? So the one, the painting, the drawing, that is Georg Wilhelm Friedrich Hegel. Then the gentleman on the right, that is the Czechoslovakian British theorist Ernest Gellner. And the gentleman below Hegel, that is Carl Schmitt. So what do these four dead white men have in common? So they do have in common that they are dead and white and men, but they have something more in common, and that is the basic insight And these are very, very famous quotes that they have made on the role of scholarship, of the role of Geisteswissenschaften, we would say. And so I go in the order of it's Hegel says, I tell you first in German, die theoretische Arbeit, überzeuge ich mich immer mehr, bringt mehr zustande in der Welt als die praktische. And now comes the most famous quote, ist erst das Reich der Vorstellungen revolutioniert, dann hält die Wirklichkeit nicht mehr aus. So Hegel says, every day I'm more convinced that theoretical academic work is much more important in the real world than practical work. And once that the realm of ideas and concepts is revolutionized, reality does not withstand. That is the essence of Hegel's thinking. And it's very similar to what John Maynard Keynes said. He said, any important thought that had been followed by politicians and social movements all over the world, it has before been scribbled by some academic at some desk. And Ernest Gellner makes it even more drastic. Ernest Gellner says, at the basis of the social order does not stand the executioner, but the professor. And very much in that line stands Carl Schmitt. In the text that you have read for this class, you will remember that he says that legal scholarship is das erstgeborene Kind des modernen europäischen Geistes, des neuzeitlichen okzidentalen Rationalismus von fast legislatorischer Würde. So it is the firstborn child of modern Occidental rationalism, and it is, if everything goes wrong, it's the last asylum of legal consciousness. So you have people from all walks of life. So the people who are on the left, social democratic, rather leftist, or as Schmitt with the authoritarian penchant, they agree on that. So you might say, is that fantasy? Is that just four dead white men who try to embellish their profession? And I think that is not the case, because legal scholars, they do not describe their law. And indeed, many people, many lawyers speak of their law, unsere Rechtsordnung. Yeah, wir, unsere Rechtsordnung, their law. They don't describe it from outside, but they are participating in it. And they are forming it from the inside. So they are forming and administrating the basic concepts and principles. With these concepts, they reconstruct, explain legitimate legal and political structures. They inspire and accompany the development of the law. They form the next generations of the lawyers. And that are the people who formalize society. In modern societies, most operations which are important are at some point formalized by those lawyers. And you being a lawyer, you will know that form deeply impacts on content. Not least, many legal academics, professors, propagate their concepts, their theories, their doctrines in the public, in the academic public, and in the general public. They write in big newspapers. They participate in political processes, and very often they do become judges. And indeed, many of the decisions that we study as legal scholars, they are written by judges who have been academics, and who are writing their sentences in order to enshrine their legal thinking into the law. For that reason, I think the assertion by these four gentlemen is particularly true when it comes to legal scholarship.
Professor, can I just ask a quick question before you go on? Just a quick introduction. My name is Martin Jarrett. I'm a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. How far can scholars go as regards their shaping of society before they become political actors? This has honestly been a bit of a burning question inside of me for about 2 years. I have different factors in my mind. I have one thinking about, well, I'm very lucky that in this German society, there's enough money to pay me a salary to do legal research. On the other hand, I don't have any political mandate of any type. I don't go out into society and say, please vote for me and put me in this position by voting for me and getting some kind of democratic legitimacy for my work. So because I, like everybody else, is taking a salary from the taxpayers, but we don't have any kind of democratic legitimacy, there must be a line, of course, that we can't cross. Do you have any thoughts on where that line might be?
So we will discuss that line in a moment when we come to Carl Schmitt, because it became an issue with Carl Schmitt. My general line is that the German society pays you and pays for your autonomy in order to give that contribution according to academic standards. So the German society thinks that in order to be a developed democratic society, it takes that space of independence, which is both intellectual and financial, of you thinking autonomously how things should be in order to be a democratic society. So, but we will come to that. So that is my understanding of what. So you get, you have a mandate, and that is the mandate that the German society pays for the Max Planck Society and for this institute to do the research that you are doing. That's my answer to that point. But we will discuss it when we come to Schmitt, where the line might be.
Thank you.
So if that is true, so if legal scholarship has that basic role, so for the European society to flourish, it needs a European legal scholarship. And the question is there a European legal scholarship? And that is a difficult question. What we certainly mostly do have is epistemic nationalism. Here we have this, and if you take any lesson from this class, what you should do is you should look at on YouTube the Monty Python German philosophers against Greek philosophers. It's a part of a Monty Python film, and you have the Germans, Leibniz, Kant, Hegel, Schopenhauer, Schelling, Beckenbauer, Jasper, Schlegel, Wittgenstein, Nietzsche, Heidegger, and later they put in also Kant, Marx. Yeah, Marx will come in later. When things go really rough, they send in Karl Marx, and it goes against the Greeks, and it's very hilarious. No prize. So it's an English film. It's a Monty Python. So no prize for guessing who wins at the end. But you will see that. The point I want to make is that if we look at legal scholarship, it is, we have a deep, in most fields, and most people, we have epistemic nationalism, and that means that most academics mostly work with authors and intellectual traditions of their home country. Sometimes it is enriched with scholars from other cultures, which are deemed authoritative for that tradition. So since the United States of America is the hegemon of the West, of course, American authors have a very important role in scholarship in most countries. But think, when did you for the last time engage deeply with a scholar who is working at an Italian, Spanish, Polish, or Hungarian institution? It's likely that that is something which is very rarely. So there is this question of how to set up a European legal scholarship, and that brings me to Carl Schmitt. And why is that the case? The case is that there's one tradition in European legal thinking that if a problem comes up, you think about the problem by reinterpreting a text of a classical author. Now, that is just one way in dealing with new problems in a geisteswissenschaftliche way, and that's the way how I do it here. And that brings me to Carl Schmitt. So why to discuss this question with Carl Schmitt's Plight of European Jurisprudence? So the first reason is that it's the most famous book on the issue. If you look up Europäische Rechtswissenschaften, European legal scholarship, you will see that this book, published in 1950, is the most famous book, the most quoted book. And that is no accident, because Carl Schmitt, I think it's safe to say, has been the most influential legal academic of the 20th century. Of course, there are other people who have a claim to fame, and people of a better democratic pedigree, such as Hans Kelsen. But most of the other people who are famous within legal scholarship, their fame rests within legal scholarship. Whereas Carl Schmitt is not just very famous in legal scholarship, he is very famous in philosophy, he is very famous in political theory, he is very famous with historians, he is very famous with literary studies. I think he is the most famous legal academic of the 20th century, and that is because he was an extremely powerful thinker. And for that reason, he's a good person to talk to. He wrote on the situation of European legal scholarship. So being such an important author and such an important book, it's a good place to go into it. Very briefly, this book also has a particular role in his career for reasons that we will look to briefly. After 45, his career ran into severe problems because he had been very strongly affiliated with the National Socialist movement. And this book in 1915, it comes out to relaunch his career in post-war Europe. And in fact, he relaunches his career with two books. It is this one, Die Lage der europäischen Rechtswissenschaft. And then a few months later, he comes with Der Nomos der Erde im Jus Publicum Europaeum, the Nomos of the Earth in the Jus Publicum Europaeum, and that is a world famous book. And these books, they stand together. So if you have that approach to think about new problems by reinterpreting texts that have been important, that is the text to read. Now, of course, should one read Schmitt because he was a Nazi? And here again, you see the importance of Schmitt. You see here a copy of die Deutsche Juristenzeitung 1. August 1934. And you see the title of that article, Der Führer schützt das Recht. Der Führer protects the law. And that indeed is the most important sum of National Socialist thinking that we have. It's the most famous sentence in which Schmitt is absolutely apologetic about the first crimes that the National Socialist government had committed at the very beginning of its reign to stabilize its power. So he is deeply compromised by that. He was not he became a Nazi once that the National Socialists became into power. Before, he was an authoritarian conservative who was with the Hindenburg governments. He was of the traditional authoritarian part of the political spectrum. He moved to National Socialist only once they gained power. And for a time, he hoped that he could convince the National Socialists for his type of authoritarian statism that underlies his scholarship. Of course, he did not succeed, and indeed, quite soon he fell out with some parts, at least, of the National Socialist establishment. However, after the war, and I think I should share that with you, Karl Löwenstein, another German academic who had to leave Germany and who went to the US, who developed the theory of militant democracy that is now so much quoted against Poland and Hungary. So the idea that Europe should be a militant democracy, that is a legal thought that has been developed by Karl Löwenstein when he was exiled in the US. When he came back as part of the American troops, he made sure that Carl Schmitt was put into prison for his academic writings. Yeah. And then, and I think I should share it with you, when he was then there in custody, the question was whether he should be indicted in the Nuremberg procedures for war crimes, because he had published a number of texts which conceptualized the idea of large space orders. And these concepts of large space orders was seen as a justification, as a legal justification for the German expansionist policies in World War II. And it comes to, and it comes now, and that is the question of Martin Jarrett, to the responsibility of legal academics. So they have a foundational role, but how far is their legal responsibility? And that question is discussed with Robert Kempner. So Robert Kempner is the American attorney who then does the interrogations of Carl Schmitt. So Robert Kempner also is a very interesting person. Now he's an American attorney, but he was an attorney in Berlin. He was a German, he was a Jew, and he was an attorney in Berlin. And in 1932, Kempner tried to outlaw the National Socialist Party and to start a criminal proceedings against Adolf Hitler for high treason. So he tried at the very end by legal means to put that to an end. So you can imagine it's someone who is extremely, extremely critical of what Carl Schmitt has been doing. And so Kempner confronts Schmitt with his writings. and says, you're writing both der Führer schützt das Recht, what we are seeing here, and particularly the later writings on large-scale orders, that has a responsibility, and perhaps a criminal responsibility for what Germany has been doing in World War II. And Schmitt responds that his writing is of a reconstructive kind that he would still defend in any academic setting all over the world. And Robert Kempner, the Jew who has been fighting the National Socialist movements already in the early 30s, lets him go. Because he says, although law and scholarship is so important, there is no criminal responsibility for academic writing. That is the position taking. So Schmitt comes out of the prison and tries to relaunch his career in post-war Germany, in which he is not successful. So although there is no criminal responsibility, Schmitt, who stands with his thesis, is socially sanctioned in a way that many people don't quote him anymore. He is cut out. He's an outcast. So there is a responsibility in that sense for academic writing. So how to deal with compromised scholars and also compromised authors. Here you see Carl Schmitt with a very close friend of his, which is Ernst Jünger, one of the most famous authors celebrating World War I, and an author that has been famous all over the German history. He just died, I think, 10 years ago, 100 and something old. How should one approach scholarship of intellectuals like Schmitt? So I think it's fair to say I don't deal with them, I don't quote them, I don't engage with them. I think that is a decision people can do. But at the same time, their thinking is very often so rich that there is a loss in not engaging in them. And there's a famous quote by Derrida, another Jewish thinker. Derrida, who engaged deeply with Heidegger, and he was asked, Derrida, but how can you engage with someone who has been so compromised with National Socialism? And Derrida answers that great thinking entails of being dangerous thinking. So these people, they do have insights, and we have to be careful when dealing with them, but we can use them knowing who they are. And many people did engage with them, people who are certainly not suspected of being right-wing authoritarians, such as Jürgen Habermas. You know, he deeply engages with Carl Schmitt, and the same is true for perhaps the greatest living intellectual on international law, Martti Koskenniemi. Much of his writing of Martti Koskenniemi, you cannot understand it without having read Der Nomos der Erde. It is really built on those Schmittian insights. For that reason, it is dangerous, but we can gain a lot of insights from those texts. And if you have read them, the text, you will see just how inspiring this text is. So that brings me to the third part. Perhaps at this point we can have a 5 minutes break. So let's break for 5 minutes. I open my window, get some fresh air, and then we continue at 11. Is that okay? Yes. Okay. So 5 minutes break. Thank you. Okay, so welcome back. Perhaps before I move into the third part, are there any things that we might discuss at this point? Are there any questions? I'm very happy to take questions because then I see that there is a live audience on the other side.
Can I speak again? I don't want to keep taking the floor, but perhaps just to kick everybody off. You were talking about the issue of we know that Schmitt was a Nazi. There's no grey there. He clearly admits it. And then we have a choice to make as scholars. We can simply ignore him and say, well, he was a Nazi. I don't want any kind of association with this type of person. Therefore, I will never read his work, never cite it or anything like that. But then you also say, well, there is so much rich scholarship in what he has written. And undoubtedly that's true. And I think that's actually a test for most scholars, which some, I think, fail at, to put aside their personal political views and engage with scholarship just according to its merits to see what one can learn from it. And I think Schmitt really tests every other scholar in that regard by him saying, I am a Nazi, but I've written all of this rich scholarship which you might learn from and, of course, challenge if you can. So in that way, I think he's quite an interesting figure in that he tells us, put aside your personal preferences and engage with me on the merits. And I think if academics could keep putting aside their personal preferences and start engaging with scholarship on its merits, then we can make some further steps forward. That's just a comment. Thank you.
No, that is correct. Even though one has to see that the academic output of scholars and their political worldviews are very often closely connected, in particular if it comes to more basic issues. So there is a link that one has to see, and I think with Schmitt it's certainly the case. Okay, so we are coming to the third part of the class, and that is we want to deal very briefly with the core idea and the development of the book. So we will have a look at the chapters and the core ideas of it. It's a very short book. So very briefly to think, when we are reading such a book, how to proceed. And when I looking at a book, I'm trying to have a three-step procedure. One is that I think once I've read a text, I want to know, what do I want to remember from this book in 20 years time? So what do I take from it as its core idea, and what is my impression of the author? Do I hear the name Carl Schmitt, so what will be my lifelong association when that name comes up? What does the book stand for? So just some basic insights that one can take from the book for one's own interest. How do I develop with it? That's what you take for it for a long time. But then, of course, one has to go closer into the book, and then the next step is to reconstruct what is the line of reasoning. So when I look at a new book, I spend a lot of time on the title and on the table of contents. And if a table of contents is well construed, it gives you a deep inroad into the basic thinking of the book. So be careful when choosing titles and table of contents. For example, to me, it's a very strong indication if a title is 3 lines long, or if chapter titles are 3 lines long. To me, it's a very strong indication that the whole thing is not really thought through. Because if something is thought through, you can bring it down to very few words. The longer the title, the higher the suspicion is that the whole thing is not mature. Of course, there are counter examples, but for me, that is a strong indication. So then, so that is then to reconstruct the line of reasoning. And then the last one is to go really into the individual arguments to see how is the argument construed and does it convince me? So that is then very often textual interpretation. What are the core ideas of this book? The core idea that we can take from it is that Schmitt thinks that a well-operating legal order depends on a body of rich and developing legal scholarship. That is, legal scholarship is not just an additional element that is more or less irrelevant, but it is foundational. That's the first. The second point is that legal scholarship must operate on an autonomous basis. And I think that is very interesting in our times where interdisciplinarity is so much praised. So one thinks that a legal author who is not working with economic theory or literary theory or historical theory, but who does autonomous legal scholarship, that is outdated, that is not adequate anymore. And here we have Schmitt who says, no, it's the opposite. So in that sense, this book goes against the prevailing understanding of what is great scholarship, and for that reason also I think it is interesting. And then the book gives a personification of what a great scholarship is. And you have seen in the book the praise of Savigny. And of course, Schmitt presents Savigny as the example to follow. But if you read between the lines, he proposes two people. One is Savigny and the other one is Schmitt. And it's not so easy to detect. So you can imagine that in a way tries to strengthen his role in post-war Germany. Now, what is the line of reasoning? It comes in 6 chapters. The first chapter is that European jurisprudence is a historical fact, and that is a typical Schmittian entry, because Schmitt very often starts with an assertion that surprises completely. And that's just his way of writing, to start with something that people thought differently and to state the contrary and then to make that point. So that is the point that he makes here. He says there is a European legal scholarship. There is European legal, and he claims that 5 years after the war, when most scholars could not travel, and where many scholars in France, in the Netherlands, in Poland, they would abhor to form with the German legal scholars, who many of them were part of the German criminal enterprise, to form with them one legal scholarship. But that's the way how he starts, and the genius of Schmitt is that in the way that he puts it, he makes us see something that we haven't seen before. So that is what he does in chapter 1. Then chapter 2 is then in the English translation, it's Roman law as the agency of European scholarship. There is, just to note, there is an error in the translation, because in German it's die Wissenschaft vom römischen Recht. So that Schmitt does not claim that it is Roman law, the law of the Romans 2000 years ago, which has that agency, but it is the science, the scholarship of Roman law, which is the agency of European scholarship. So it is the science to which he gives that role. And in that chapter, he makes a very important point also for the institute I'm at the moment, here the Max Planck Institute for Legal History and Legal Theory. He says in that chapter, he says there are two routes for European legal scholarship today and European law. And Schmitt in this chapter claims that the main source of European law is Roman law as reconstrued by Roman legal scholarship. And that indeed is the logic on which the Max Planck Institute on European legal history has been formed. It was founded by Helmut Koing, who was a very famous Roman law scholar, and it was set up with the idea to find the basis of European legal scholarship in 1964. So in a way, this piece here elaborates the theoretical basis for this institute. But in that chapter, Schmitt also makes another claim, and that is that the principles of modern European constitutionalism, so separation of powers, parliamentarism, that is a second strand. And if you think back on what came out in Article 2, the article that we started with, we see that the political decision today has been to build European law on the principles of modern European constitutionalism. Yeah, rule of law, human rights, pluralism, and these concepts. It's not Roman law. It is modern European constitutionalism. But in that chapter, Schmitt opts, for reasons that become clear later on in that piece, he gives the preference to Roman law, but at least he sees also the role of constitutionalism, which is the basis as we use it now. Then we have the third chapter. The third chapter then is on the crisis of state legality in the 19th century, the possibility of a distinction between law and the legislator. So for Schmitt, who was a deeply conservative person, the idea that a liberal parliament starts legislating and thereby transforming society, in particular in the core fields of the private relations, as well as the basic relationship between the people and the sovereign, that he, being a conservative, is deeply troubling. And that is the reason for his critique of positivism. So that the law at the end is only the legislative output that comes out of parliament, and moreover, a liberal parliament where you have a lot of compromises, you have party politics, and that is to him is a deeply unsatisfactory way of creating the law. So that is that development, the full positivation of the law that takes place in the 19th century, and that he sees as the first crisis of state legality. That's the moment where legality and legitimacy are starting to move apart. That then worsens in the 20th century. It's the motorized legislator, and there he refers to the situation that we are also confronting today. So you have the crisis of modern capitalism, and the crises of modern capitalism require an enormous output of legislation, and that is not just parliamentary legislation, but that it is also executive lawmaking, and lawmaking by many other agencies, which comes out in order to stabilize that type of a society which is always running into apocalyptic situations. So that is then the second crisis, because then the normative production becomes so overwhelming that the rationalizing contribution that comes from legal scholarship cannot be maintained in light of this normative production. If Schmitt was still living, he would see that his worst nightmares have come true, not least for the normative production of the European Union, but also for all the judge-made law. Schmitt at his time was not really conceptualizing a judge-made law. Today, most of us who are working in the positive law, very often the sources which are most important are not just the legislation and the executive lawmaking, but much of that is judge-made law, European Court of Justice, European Court of Human Rights, the German Federal Court, the German Constitutional Court, and many, many other courts in many countries. So there he describes the critical situation, and then in chapter 5, which is the most important chapter, he presents Savigny as an alternative paradigm. And Savigny is the paradigm because Savigny distances himself from that positive lawmaking and gives the core role to legal scholarship. Yeah, Savigny gives to legal scholarship an almost legislative dignity, and that is the point that Schmitt wants to underlie in this piece by stating that this type of the specific rationality that that legal scholarship gives to the law is the basis for law operating well for a well-ordered society. So he brings out this position of Savigny, and then it comes to the last chapter, where he posits jurisprudence as the last refuge of legal consciousness. Also here, there might be a problem with the translation, because in the original text, Rechtswissenschaft provides the asylum to legal consciousness, and that is a different role, because it's a place that provides asylum is a powerful place because it can protect. Whereas here, jurisprudence as the last refuge of legal consciousness, here it looks much weaker, this is why, and we will come to that in a moment, the translator entitles the book as "The Plight of European Jurisprudence." We will come to the question whether that is the correct translation of "Die Lage der europäischen Rechtswissenschaft." Okay, so that is the basic line of reasoning. We move on, and now we are coming to the fourth part, and that is to think what does Schmitt propose as European legal scholarship? How does he propose it? And just to tell you, I think that the way how Schmitt presents European legal scholarship, that is deeply flawed. It does not work. His concept is not convincing. But as with many other things, conceptual proposals for Schmitt, thinking through what he sees as the phenomenon and how he conceptualizes it, going through that process brings out a better understanding of the phenomenon. So ist das jetzt schon 15? So European legal scholarship, we are trying to grasp the phenomenon. And the first interesting thing is, and it might have struck you, that Schmitt conceptualizes European legal scholarship without European integration. And that is surprising because his piece comes from 1950. So the Council of Europe was already operating. Churchill had made his big talk on a European federal state. The European Federalists were a very active and publicly visible institution. It was a true public topic, and not least, many German Nazis and also many lawyers who were important to the regime, they reinvented themselves as European legal scholars and as people favoring and advocating European integration. One important example is that the European flag. There are two people who claim, the blue banner with the 12 sparkling stars. There are two people claiming the authorship of that flag, and it's an irony. One is a Holocaust survivor, a Jewish Holocaust survivor, Levi, and the other one is a person who was a prominent race theorist for the Nazi regime, and who then reinvented himself, and in that process created this flag. So many people reinvented themselves as Europeans, many Nazis, but Schmitt did not. And so that is something to note, and one has to think why did he do that? Why didn't he link up to this European movement? And the reason is that to him, this was just giving in to the hegemonic Western forces. So to him, the European integration, it was just part of the Anglo-American plot of putting down Germany, and there's much to it. Without the Americans, European integration would have never happened. It was an American project, and it remained an American project for a very long time. And perhaps so, without American support, European integration very often has been critical. So that is one thing. So what is then the basis of European legal scholarship? And so one reason is a wonderful polemic that he makes against Gesetzespositivismus, so that just the dominant way of looking at the law is just incapable of seeing this important phenomenon. That is one of the arguments, but the core argument is that there is a consonance of basic concepts and structures. He says you look at any European legal system and you will see that the basic concepts are the same, that the structures are the same, that so the concepts such as the person, the will, the contract, damage, guilt, rights, representation, separation of powers, all these are the basic building stones of law all over Europe. And for that, and he says on that basis there is a European legal scholarship, because at the end scholars all over Europe are dealing with the same concepts and the same basic structures, which spring either from the tradition of Roman law or from the tradition of European constitutionalism. Now, I think that does not work. I think that European legal scholarship without European institutions does not work. And the first is because legal scholarship cannot flourish without institutions. So it needs chairs, it needs learned societies, it needs journals, it needs a social substratum in which it lives. And that substratum at the end is furnished by public institutions. It needs public money and it needs public institutions. It needs universities. And that did not exist for a European scholarship at the time. And for that reason, the idea of Schmitt does not work. And in a way, it is surprising because Schmitt, who thinks in the tradition of Hegelian thinking, is a deeply institutionalist thinker. One of his important concepts is concrete orders. So any law, to understand any law, you have to see it as part of a bigger unit, and that bigger unit are institutions. So if you think about European law, you have to think about European institutions. Otherwise, it cannot work if you are an institutionalist. And it is very surprising that, so in the tradition of Schmittian thinking itself, his position here on European legal scholarship is problematic. Then another point why it is problematic is because it is a forced merger. Again, I made that argument earlier on. We are just 5 years after World War II. Many German legal scholars are deeply compromised. Just on a different note, the person who became the first most prominent German scholar on European law, Hans-Peter Ibsen, who wrote perhaps the most famous German book on European integration law. He closed as the German occupying officer the University of Brussels. So it's so a forced merger after World War II that is deeply problematic. But on a conceptual level, if we take Schmitt's position, Schmitt's core argument that the core concepts and the core structures are the same: person, will, contract, damage, guilt, rights, representation, separation of powers, we would not have a European legal scholarship, but a global legal scholarship, because these concepts are the basis of legal arguments, not just in Europe, but also in Latin America, also in North America, also in Africa, and even in China. If you look at, even in China, you have damage, you have contracts, you have guilt, you have the person. And it is claimed that there is even something like an independent judiciary. So for these, if Schmitt's claim that it is the similarity of the basic, or the identity of the basic concept and the basic structures, we don't have a European scholarship, but we do have right away a global scholarship. So that does not work. And then it is another reason why it is not a European legal scholarship is that we have a US hegemony in most fields. So perhaps you don't have a US hegemony in European legal history, in canon law, or in some fields of criminal law. But on all issues that are crucial for the world society, so be it mergers and acquisitions, contracts, the law of war, international economic law, and all these issues, you certainly have an Anglo-American hegemony and probably an American hegemony. So it's very likely that of the 10 most quoted authors, 8 of them are working at US faculties. So for that reason, Schmitt's understanding why there is European legal scholarship does not work. And indeed, the founding director of this institute here, Helmut Koing, he made the point still in 1991 that European scholarship is still a prospect for the future. And that by the director of the institute that has been precisely formed in order to build a European legal scholarship, he makes the point that still in 1991, after the Iron Curtain came down, that there is only very few elements of what we could meaningfully see as European scholarship. So that brings me to the next point. So out of the problems that we see in Schmitt's way to conceive a European legal scholarship, and we see that what he is proposing is not standing scrutiny, particularly because we need institutions. We have to think, what are the institutions in building European scholarship? And here there are some I want to name. One is la Fédération Internationale pour le Droit Européen. That is how it was called, the International Federation of European Law. It was formed by European institutions, by the Court of Justice and the European Commission in '61. By the way, crucial has been Walter Hallstein, who used to be a professor at Frankfurt University. There is no other university in Germany that has had an important role for European integration as Frankfurt University. No other institution has sent as many important people to the European institutions as has Frankfurt University. And one among the many is Walter Hallstein, who was crucial in founding the International Federation of European Law. Then we have the College of Europe, now which started at Bruges, and now is also operating in Warsaw, in Natulin, who is forming the core of the lawyers who are then staffing European institutions. Then we have the European University Institute, which gave a very important contribution, the most important being the one orchestrated in the late 1970s and early 1980s by Joseph Weiler, who then started with Mauro Capelletti the integration through law series, which remains until today the most famous legal academic project on European law. Joseph Weiler now being a professor at New York University. Then Jean Monnet chairs were founded, and last not least, and I think that has been the crucial thing, it's the European Research Council. Why is the European Research Council so important? Well, the unit on which the academic work, the academic system works, that is academic reputation. So the people here in the banks, they strive for money. The politicians, they strive for power. And academics, they strive for reputation. And the European Research Council has positioned itself as an institution that conveys enormous reputation. If you see university presidents and university rectors and ministers of science, when they meet and they want to show how important they are and how important the university is, what they bring out is how many ERC grants they do have. Because Nobel Prizes, they are not enough. You cannot do that counting on Nobel Prizes, but the most important currency now when it comes to academic importance between institutions and also academic importance of academics, that is the European Research Grant. Yeah, is it a starting grant, is a consolidator grant? That has become the currency, and that really is a huge engine that brings about European legal scholarship. So some thoughts on method and identity of that scholarship, and again we turn to Schmitt. So here it might be useful again to start again with the title of the book. So Schmitt speaks of die Lage der europäischen Rechtswissenschaft, and that is translated by jurisprudence. Now, of course, that is a very different thing, because Gilbert and Russell might correct me, but jurisprudence in the Anglo-American world mostly means legal theory and philosophy. So jurisprudence is mostly not the treatment of the law in force, but it is something which is beyond the law. It's theory, philosophy, beyond the law. Whereas for Schmitt, it's the opposite. For Schmitt, Rechtswissenschaft, it's the law itself. So it is a very, very different understanding of the very object of the research. And the next then is it the plight? So the title of the book is Die Lage der europäischen Rechtswissenschaft. The Lage is the situation. And it is very important to see that concept, the situation, because that was an important concept to Schmitt. Another book which is very important to him is Die Lage des Parlamentarismus, so the situation of parliamentarism. So it's an open way to look at it. It's how is the concrete situation of a certain phenomenon at the moment. And with plight, the translator gives a very strong interpretation of an element that might be in the book, because yes, Schmitt says that the situation for legal scholarship is difficult. In that way, plight is not a crazy translation, but it is a very one-sided translation of the title, because die Situation der europäischen Rechtswissenschaft is also that it provides asylum to legal consciousness. So it has a very important role to play. So what is that promise? And here I want to read with you a very important paragraph of the book, in which Schmitt lays out a core element of his thinking, and which I find interesting for the role that it gives to autonomy, and for the way how he invites us to rethink the issue of interdisciplinarity and our role with respect to other sciences. Not least because the European Research Council very much pushes pressure on legal academics to present themselves as interdisciplinary. And indeed, if you want to be successful with the European Research Council, one of the recipes to be that is that you say you apply a very trendy method or theory from another field to the law, the most important being economic analysis. So Schmitt tells us that is wrong, wrong, wrong. And not least for that reason, it is interesting to engage with Schmitt, because he gives us a critical take on what is the position of the most important force in Europeanizing legal scholarship. So I will now read this part to you. It's on page 66 of the original text. It is: since the 19th century, the situation of European jurisprudence has been determined by the split of law into legality and legitimacy. We have spoken about that. The danger the spirit of European jurisprudence faces today comes no longer from theology and only occasionally from philosophical metaphysics, but from untrammeled technicism, which uses state law as a tool. Now jurisprudence must take a stand against the other side. So the scholarly jurist is no theologian and no philosopher. That is a very important point here. Many people are taking Schmitt as a philosopher, as a political theorist. And Schmitt is adamant that he is not a philosopher and not a political theorist. Schmitt always makes clear that he is a legal scholar and that his books and his texts are to be judged and evaluated as being legal scholarship. So the scholarly jurist is not a theologian and no philosopher, but he is also no mere instrument of arbitrary prescription and endless enactments. We must now withstand the subaltern instrumentalization, just as in other times we have had to resist dependency on theology. We remain a science and a jurisprudence against both sides. That is the reality of our intellectual and spiritual existence, which we should not allow to be diminished by methodological, psychological, or general philosophical arguments, because we fulfill a task which no other human activity can fulfill. We cannot choose the changing rulers and regimes according to our own tastes, but in the changing situations, we preserve the basis. And now comes the core of the rationality, which according to Schmitt is preserved in legal academic. We preserve the basis of a rational human existence that cannot do without legal principles such as a recognition of the individual based on mutual respect, even in a conflict situation, a sense for the logic and consistency of concept and institutions, a sense for reciprocity and the minimum of an orderly procedure, due process, without which there can be no law. That we defend this indestructible core of all law against all destructive enactment means that we maintain a dignity which today in Europe is more critical than at any other time and in any other part of the world. So the core argument that Schmitt makes here is that that of the autonomy of legal scholarship, and that in the German tradition has two sides. One is the side of doctrine, and the other side is the side of Grundlagen. Grundlagen mean legal theory, legal sociology, legal history, and methods being the most important one. So he claims the autonomy for both. So what does that mean? And that brings me to the last slide. Schmitt invites us to be legal scholars, being a jurist. And that has a very liberating, so that is an element of identity, of freedom, and of method. And what do I mean by that? Well, I think it's clear that the method for doing doctrine is an autonomous method. Yeah? No economist and no psychologist and no philosopher can tell a legal academic how to do doctrine. You know, it is evident that that is something, how to do it, that is specific to us. But what is different is the question of when it comes to Grundlagen. So to discussing issues which are beyond doctrine. And I think many of the people who are now listening to me, they are not satisfied with doing only doctrine. They want to do Grundlagen in some way or the other. And there is the question how to do that. And here is my liberating idea and the liberating element that comes from Schmitt. Because Schmitt, although he was able to do very fine doctrine, has mainly been someone doing Grundlagenforschung. So he did state theory, constitutional theory, that was the theory of public law. That was his field. And And he does that in a very, very, very successful way, because he becomes probably the most famous legal scholar of the 20th century. And he does that writing as a jurist, as a legal scholar. Of course, he is not limiting himself to writing just doctrine. Rather, he has a very far-ranging thought. He speaks, and you have seen that he speaks with history, with philosophy, with history, conceptual history, with theology, political science. So he speaks with many fields, but he speaks with them being a jurist. And that is the key to do it in a, so he, as a jurist, and therefore from an autonomous point of view. And that makes it possible, because us being trained as lawyers, it is impossible to really tackle the theory or the methods or the academic output of any other field in a way that people from the field can do it. I remember many situations where a legal scholar puts out some thoughts on political science or political theory and is very proud on his or her insights, and then comes someone from political science and says, yes, that was an interesting article published 6 years ago, but since then everything has changed. So almost never we can live up to that. But that is not the point. If we say that the Grundlagenforschung that we are doing is part of legal scholarship, that gives us autonomy in all senses. So first of all, for the questions that we are asking, we are asking legal questions, questions of validity, questions of legal legitimacy, questions of understanding legal institutions, questions of the sources. So we are asking specific questions. And on the basis of these specific questions, we engage with other fields. And when we engage with other fields, we can, and Schmitt shows that very clearly, we can be eclectic, we can be syncretistic, I hope that is a proper English word, and we are all mostly reductionists. And indeed, if we receive insights, theories, concepts from other fields, if you speak with someone from the other field, very often that is problematic by the standards of the other fields. But that should not concern us too much, because we are practicing that type of interdisciplinarity in an intradisciplinary space. We are doing that not as historians or philosophers, we are doing that as legal scholarship, as juristische Grundlagenforschung. That does not mean that anything goes, anything but the standard for good scholarship are our standards. It's the standards of legal academia. And these standards are somehow more lenient than it would be if you were a political theorist, if you're working with some element of political theory, or if you work with some element of economics. But we do have our proper understanding of how to do that. So it's the traceability of the argument that we are developing. It is the internal coherence of the argument that is developed. It's the correct engagement with the other thought. So what you are reporting, that is correct, that the author that you are quoting has truly said it. So that there's accuracy in the reporting. So there are some further elements. So if we reflect them with the concept of the theory of truth, we see that in legal scholarship, we have quite an interesting combination of the theory of truth, of correspondence, of consistency, and of consensus. And with these concepts, we can build our Grundlagenforschung up on the ivory tower that you see on the slide. And in that ivory tower, we have our autonomy, we have our freedom, we have our own standards, which we have to fulfill and by which we control our peers, but it is us, legal scholars, who control the standards. And there is one, and that brings me to an end, and that will be very, very, very polemical in the house that I am standing now, because here the position has been the opposite to what I'm saying now. So I hope very much to engage with someone here from the house. But in my understanding, the ultimate test of that form of Grundlagenforschung is its eventual potential and fruitfulness for doctrinal research. So when we do Grundlagenforschung, we are very free. There are standards, but we are very free. But the proof to the pudding is that it helps us to reconstruct the law in force in a more powerful and meaningful way. So in a way, what we are doing in the Grundlagenforschung, that is similar to what the production of hypotheses in the natural sciences. So theories, hypotheses are construed, and then they are tested in the experiment. And in my understanding, the usefulness of Grundlagenforschung in doctrinal reconstructions is what experiments are in the natural sciences. And of course, here at the Max Planck Institute has been a very different understanding in that point. The opposite has been held, but I think that this understanding is, at least for much of the Grundlagenforschung in the law, I don't say that you cannot do legal research and then being part of history. I think that is a way of doing legal research, that you say we are not anymore part of legal scholarship, but we are part of historical sciences, and we are looking at the law from the other field. That is certainly a possible way of doing it. But I think it is equally possible, and for most lawyers much easier to do that at the interdisciplinary, as an interdisciplinary way under our own concepts, under the premise, however, that then the eventual criterion for the academic production that we provide is its potential and fruitfulness for doctrinal thinking. Now, there is some time left, and I'm very curious what kind of reaction these thoughts find. Thank you very much for your understanding.
Thank you very much for this amazing talk. I have raised lots of issues in my mind, but let's open the floor. If you could raise your hand, I can see everyone on screen. If you have a question. Oh, sorry, yeah, there is one. Can't pronounce your name, Agne, is that it?
Yeah. Yes, so it's Agne. So I come from Lund University in Sweden, but I'm originally from Lithuania. And I'm doing my PhD here in Sweden. And sort of two thoughts which are sort of connected, but not really, were going through my mind whilst listening to this lecture. One is that there is sort of now in Europe these conversational chambers, in a way that certain academics from certain countries sort of just talk with each other, sort of engage and make references to the other echo chamber. But there is no real sort of conversation that leads to sort of different approaches in those echo chambers, if that's clear. And I would use an example that it would make more sense is, for example, the rule of law debate. If you read publications, they're sort of speaking in the same terms with the people that they agree with, but then engage and say, oh, the other position is wrong, and there is no real engagement. So it would be interesting to hear what you think from like Carl Schmitt perspective. Is this also the segmentation of European a legal scholarship? Is this also one of our I don't know, qualities of that scholarship? And the second thought was the final moment where you showed the ivory tower and said like, oh, we should put sort of the doctrine on top of it. To me, I'm not sure, but it seems very that law now sort of lacks tools to engage with difficult topics, especially now in Europe. There is plenitude of them, rule of law, constitutional identity, and there is different conversations happening, but they sort of don't provide the current situation solutions. Maybe is not the thing, but no way forward. So I don't know if it makes sense what I'm asking, but it would be interesting to hear what you think about this.
Yeah, I think there are two very important points, and I can only start trying to start some thoughts on that without really doing justice to the questions that you have asked. First is that you say speak of echo chambers. So here my thought is that by now there are so many academics working that it is impossible to have the idea that somehow you can communicate with everybody. Yeah, don't forget, Lauren Destin told me that she has been a director at the Max Planck Institute for Scientific History. He said, at the moment, there are more academics employed and working than all others in human history combined. So that gives you an idea on the wealth of academic production. There's just no way to deal with all that. But at the same time, I think to be good scholars, we should try to engage with people who are thinking from the other side. That's why I come to Carl Schmitt. You know, Carl Schmitt helps me to engage both with the Second Senate of the Bundesverfassungsgericht and the thinking that is close to Viktor Orban. Yeah. So we should try to engage with them and have a meaningful discussion, and also to find some people who are not coming from the hegemonic institutions. That is the first. That's on the second point. And on, sorry, could you repeat the second question?
So the second question was mostly about the ivory tower and putting the doctrine on top of it.
Ivory tower. I find it, I must say, impressive that the German taxpayer puts every morning, so at my institute, it is 56,000 euros. Every morning, the German taxpayer puts 56,000 euros at our door and tells us, do what you find interesting. And I trust that you, for the career that you have had, I trust that your curiosity developed in autonomy is beneficial to our society. So, and that's what I mean by the ivory tower. I think we are called to follow our interests, our curiosity. That is, and in the autonomy, you know, I find it so surprising that many modern societies pay so much money into autonomous spaces, but it is for the belief that that autonomy is necessary for these societies to flourish.
Wonderful, thank you. Next, we have Adolfo Giuliani. Just to say, if you want to ask questions, you can also type just a Q or a 1 in the chat function.
Thank you very much. Thank you very much, Professor Bogdandy, for presenting this immensely interesting question about to the identity of the European legal scholarship. I am a legal historian, Italian legal historian in the UK, and the purpose of the very brief words that we will say is to enter in a kind of discussion with you from the side of legal history. The legal historian is a bit different, looks at the past with particular spectacles, which are that of an observator, not a believer. Therefore, questions of the most famous leaves the historian a bit suspicious. The legal historian looks at the most significant author. Now, looking at the 20th century, the observation that the legal historian would make is that the 20th century begins against. This word, this adjective, other, was recurring in the theories that were made in the beginning of the 20th century. They came up with another legal natural law, another model of legal reasoning, another idea of order, another idea of legal system. And that was the flavor of the beginning of the 20th century. Of course, I strongly believe, in fact, I have a book on this subject, there is one fountainhead, one particular figure that seems to be the starting point of all other discussions that run through the 20th century up to today, and that is a German legal scholar. That is Cantorowicz. Why? He made the change of paradigm, the change of episteme. He said, look, it's not a legislator, but a judge. And today, as you observed before, is judged law what counts. But also he had another argument. Let's look at the language. And the concern with language, the so-called linguistic turn, is what characterizes the 20th century and characterizes the important legal theories that have been made during the 20th century. Kelsen, Hart, through the Nouvelle Rhetorique up to today. And it's precisely the importance of language that we have today, coming up with different ideas of language that justifies what you called before the interdisciplinary approach to the law. In other words, what is the Lage of the 20th century? Judge-made law, language, and this tremendous importance of legal argument. I am a bit doubtful about the importance of Carl Schmitt. Looking at Italian legal science, the important author was Kelsen, not Schmitt, precisely because Kelsen gave models of reasoning that were able to overcome that grand descriptions of law that were taken to be with some suspicion. They wanted science. They wanted to build a legal idea that were autonomous from opinion, from politics. This is what they disliked. They turned to language, to the Nouvelle Rhetorique. And this today, the importance of language, it is the great effort of basing normativity outside of law and, for example, on language. And therefore, I think that looking at Cantorowicz and the line of thinking that comes out of him, which explains what happened in the 20th century, explains also Marti Costaniemi, which you mentioned before. I doubt that the basis of Costaniemi was Carl Schmitt. Well, the title of his book, from apology to the structure of international legal argument. His concern is with argument and legal argumentation. We know has been one of the great presences in the 20th century, then and today as well. Therefore, the importance of a legal historian is precisely to, if we can say, to digest what happened. It's extremely important to understand the Lage of today's legal science. Thank you very much, and I'm very grateful for your presentation and for your immensely interesting question that you presented in your lecture. Thank you.
Thank you very much. That are very rich thoughts, and again, I can only react insufficiently on your first point that the legal historian is very often an observer and not a participant. Again, I don't want to say that type of legal history, I say you are right, that certainly exist, and I also think it is important. At the same time, I want to stress that many legal scholars who want to work on and give an input in the law on the current law, many of those texts, and very often the most important texts, they come to their question first via a reconstruction of the history of the phenomenon. So in many Böckenförde, Schmitt, Assmann, Grimm, whoever you take, in their important works, very often you have the first chapter, which is a reconstruction of the history of the problem of the legal institute of the question. But they do legal history. But they do legal history with a question of our times. And of course, that frames the way how they reconstruct the issue. And they are coming to the law as a participant and not as an observer. So I think, particularly in legal history, you have both.
Sorry, you might have to. You've muted yourself. Yeah.
Thank you. Sorry. On the observer, so that was very rich. Yeah, very rich, and I can only answer in an insufficient way. On the issue of the observer, I think it's certainly possible to do Grundlagenforschung, in particular legal history, as saying I'm just an observer of doing what is doing. At the same time, I want to stress that many of the most important works to the positive law, they very often come with a first chapter that is historic. Think of Böckenförde, think of Schmitt-Assmann, think of Schmitt, and many works of Koskiniemi. So they have a problem with the law as it stands. And in order to give a meaningful contribution to how it should be understood and developed, they go into history. But they then reconstruct history in light of a current problem. And very often that are very successful books. So I think you have both approaches in legal history, and both have their value. On Kelsen, so I'm also, as a person, I think Kelsen has been a person più simpatico di Carl Schmitt, and certainly very, very influential. And so I don't want to deny the importance of Kelsen. But if you speak of Italy, I think in Italy there's a huge reception of Carl Schmitt, yeah, by Miglio and Schiera, and I just saw Sabino Cassese reviewing a big book that has come out on Carl Schmitt in Il Foglio. So I think Schmitt is very present, and Portinaro writing on the Jus Publicum Europaeum. So I think there is a rich field. On Matti Koskinen, you're right that his dissertation is on arguments, but his second book, The Gentle Civilizer of Nations, if you look at that and how it is construed, it's very strong there are very strong elements that speak with Nomos der Erde. Yeah.
Wonderful, thank you very much. Can I call upon Marietta Auer to ask a question?
Thank you. And I actually be very brief because I have to leave in a minute. So I actually just want to make a remark because I feel a little bit challenged because Herr von Bogdandy, you just made such a big difference between the approach you showed and the approach done here at the Institute. But I totally agree with everything you said. So I'm totally in favor of using theory approaches or interdisciplinary approaches for the use of legal doctrine. And nobody has ever said here that legal doctrine isn't the core of jurisprudence. I would totally agree with that. So that's all I have to say. Thanks.
Okay, thank you very much. Oh, sorry.
No, just I remember many discussions with if I remember that correctly, the discussions between Michael Stolleis and the bulk of legal history in Germany. I think the Institute made very strong that if you do research on legal history, there shouldn't be a link with contemporary problems. Whereas many legal historians in Germany, they said, no, dogmatic Geschichte, that is the heart of it. So we are reconstructing the history in order to reconstruct the current law. And the Institute here has taken a stance against it. So that was the discussion I was referring to.
Thank you very much. Next, Caspar Ehlers.
Yes, thank you very much indeed for this lecture. I don't want to jump in that pool you just talked about with Marietta Auer. And so I'm not a legal historian, but a historian working on on an Institute for Legal History. I just want to follow up one of the last remarks you have just made, Herr von Bogdandy. And this is the comparison of the natural sciences and their experiments and our work. And I don't think that we can make proofs in experiments of our theories like the natural sciences could do. So one of the important differences between these two methods is exactly that point, that we can't make a waterproof proof. So we just have to consider our ideas like Occam's razor or something like that to make our arguments better, to sharpen our arguments. But in the end, we couldn't be like a nomothetic science like the physics are, or everything that's based more or less on mathematics. So my question is, within the ivory tower and looking outside of the ivory tower to other sciences, to what extent you think it is possible to do interdisciplinary works with so far-sighted, from our point of view, sciences like the natural sciences? Could they deliver some impact on our thoughts and our methods, or should we stay, and so I understood your lecture, should we stay with our own tools? We have the legal ones as well as the side effects like history, sociology, philosophy. Thank you.
Yeah. So thank you for the question, and I very much agree with you that I should not overdo the comparison with the natural sciences. Of course, using a thought that is developed in the Grundlagenforschung in doctrine, that's a different thing than an experiment. Yeah? And the truth that produces in ways of reproducibility, there are important differences. I don't negate that. But nevertheless, the usefulness remains the criterion. And so if a historical reconstruction of what separation of powers means, or what independence of the judiciary means, and we then use that in order to look at what is going on in Poland, that is helpful also to reconstruct the Polish history. You know, how has been the Polish constitutional history in light of what is going on in these days? Now that is, and if the outcome of the history tells me something on what is going on today and how to interpret Article 2, the rule of law, it is helpful. It is that type of proof that we find here. Then, if we can speak with the natural sciences, I think we can speak a lot, in particular when it comes to issues such as concept formations. You know, also the natural sciences, they do need concepts and they have to form concepts. And so I think on many steps, there is indeed the possibility to discuss and come together. So I would not exclude that working together with these fields is useful, in particular if they are doing Grundlagenforschung. Yeah.
Thank you.
We have slowly to come to an end because
we have one last question. Can you deal with one last question, or
please.
should we close? Okay. We have a question from Gustavo.
Thanks a lot. I will be brief with my question. So, Professor Bogdandy, what should be the role of legal academia against systemic crisis of rule of law? Because I'm thinking that when the foundational values that this autonomy of academia legal thinking are shaking, is there a moment that the academic should become some kind of activist when actually the same rule of law, the same foundations of a society are shaking? So I'm thinking probably that this is actually very common in Latin America, but now in Europe, in Poland and Hungary, we are seeing this. What should be the role of academics when the same foundations of the tower are shaking? Should we stay inside this tower, or that there's a moment that academics should become some kind of activism when there's this systemic foundational shifts or challenges? Thank you.
It's a wonderful question, and it's not so easy to answer. So my answer to you has two sides. One side is that science compromises itself because it takes stances using its scientific authority on political issues. So that provides the impression today that for any political position, you will find an academic who speaks on that topic with academic authority. And that is very, very bad. Because at least that is my impression. There are many things on which I really cannot speak with authority. There are many things on which I cannot say anything scientifically, because the evidence that I have, or it's just too muddled, or you cannot come to it with a scientific result. So I think we should be very careful to think on what issues we can speak with academic authority, and we should be careful not to compromise that authority by pronouncing ourselves on political issues on which we do not have academic authority to provide. That is very bad for science. At the same time, we are not only academics, but we are also citizens. And we have, and perhaps some people have trust in us, not just for our academic experience, but also for the judgment that we do have on many issues. So judgment is not an academic insight. We know that since Kant Kritik der Urteilskraft, but nevertheless, it is something that we have trained, and being academic, we have a specific type of judgment, and we can use that judgment being citizens. And I think with that, we can speak up in the public realm, and we should do so if we think that pertinent.
Wonderful. That's all the questions. I'm going to raise, as in clap my hands virtually, to say thank you to Professor Von Bogdandy for a very provocative, I think, talk, and inspiring as a result. It's definitely made me think of the idea of great thinking being dangerous thinking, and therefore what great legal thinking will be in terms of being dangerous legal thinking, and what kind of agenda that might entail for research in the future. But we'll close for now, and also thank everyone for attending. Would you like to say a last word to everyone?
Yes, I do. So I very much enjoyed this conversation. So thank you for joining in, and I hope there will be a follow-up in this conversation. Thank you.
Okay, wonderful. Thank you very much, everybody.
Bye-bye.
Bye-bye.